What if a lender invokes the due on sale clause following a subject to purchase of the property? So the buyer has acquired the property subject to the existing loan. The lender determines that falls within the due on sale clause and gives them the right to invoke the due on sale clause and accelerate the debt. What happens? So universally, it's not required as part of the language, but in every due on sale clause that I've ever reviewed, whether that's through a private lender, whether that's through conventional Fannie Mae, Freddie Mac, FHA, VA, every due on sale clause that I have reviewed has a provision in it that states that if the lender is going to exercise its right under the due on sale clause, it will send a notice to the borrower stating that they have 30 days to pay the full balance of the loan because the property has been transferred to a third party. So that's a pretty standard provision and something that the lender has to do. So they basically provide what we call a notice of acceleration in the legal realm, but it's basically a notice saying, hey, you've sold the property, you've conveyed the property in violation of the due on sale clause. We now have a right to require that you pay the loan in full. Now, within that 30-day period, the lender generally includes in their notice of accelerating the debt. Now, they don't have to do this. If you look at the express language of the due on sale clause, it generally is not something that the lender has to do. They basically could fully accelerate and say, you have no option. You have to pay us in 30 days. But that's not normally not what the lender does. Normally, their letter that goes out states that, hey, look, you've transferred the property. You have 30 days to pay the loan balance, or alternatively, you have 30 days to put the property back into your name and to come back on title to the property. So what does that mean? Well, in that case, you can, as the investor or the purchaser, if the seller is willing to cooperate, you can work with the seller to restructure the transaction so that title is put back into the seller's name. And the way you do that is you execute a warranty deed from the buyer to the seller, which conveys title to the property and puts it back into the seller's name. In conjunction with that, you work with the seller to restructure the transaction. And there's a few ways to do that. One is you can restructure it using an agreement for sale, which is, and we've talked about this over and over on the show. It's basically, some states call it a contract for deed or a land installment contract, but it is a document that, or a contract that basically states that I, as the buyer, have an equitable interest in the property, which includes full possessory rights to the property, and I can use the property as my own. However, I don't have fee simple title. The warranty deed remains and title remains in the name of the seller, and I have to make payments to the seller pursuant to the terms of the agreement for sale. Generally, if it's a subject to, you would be making payments identical to the existing loan. I'm going to make payments according to our agreement. And then when I fully pay and perform, then the warranty deed is transferred back into my name. So you can do an agreement for sale. Now, the agreement for sale is generally, and I recommend that it is recorded with the county recorder's office where the property is located. And most due on sale clauses, not all of them, but most due on sale clauses are going to say, well, that would also be a violation. But you put the property back in the name of the seller, and then you go forward with the agreement for sale. And then the lender has to decide at that point whether or not to, say, well, we don't like the agreement for sale. In my experience, lenders are less concerned about an agreement for sale than a straight warranty deed transfer, because the seller still maintains fee title, ownership of the property. They just don't have full equitable ownership or possessory rights to the property. So, the lender may be like, okay, we're good. Title went back into the name of the seller. We're not going to further invoke the due on sale clause. So that's one option. The second is to execute or put in place a lease for the property, a long-term lease with an option to purchase. Now, a couple of things. Many due on sale clauses don't prohibit long-term leases of the property. Some of them do. Some of them say, well, if you lease the property for more than 3 years, that would be a violation of the due on sale clause. Federal law basically says that a borrower can lease the property up to 3 years without there ever being a due on sale clause issue. So you have up to 3 years, or if the due on sale clause doesn't specify, then you could lease it for 5 years or 10 years, and it wouldn't be a violation of the due on sale clause. You would have to look at the language. But in any event, you can enter into a lease that either complies with the Garn-St. Germain Act, which is federal law, by making it no more than 3 years, or you enter into a lease for a longer period if the due on sale clause doesn't prohibit it, with an option to purchase the property. And then if you structure it that way, you don't have a due on sale clause issue. You would have the ability to, have that option to purchase along with that lease in place. And lenders are not going to take issue with that, even though potentially, and it's kind of gray whether the option to purchase would, create a trigger for the due on sale clause. Generally it doesn't. And generally lenders, even if it does, aren't going to care about an option to purchase. So those are the ways that you would restructure. So basically, you would, if you're going to restructure, you would pay off, or you would convey the property back into the name of the seller, do an agreement for sale, or convey the property back in the name of the seller and do a lease with an option to purchase. Now that's one option. Now let's say the lender invokes the due on sale clause and you're like, I don't want to restructure. Well, you have the right within that 30-day period to go, as the owner of the property, as the buyer, to go and sell the property to a third party and pay off the loan. So you can do a traditional sale of the property. You can sell the property, you pay off the existing loan, and you're free and clear, and there's no issue there. So that's your second option. The third option is to refinance. You could find a lender. Now, it may not be the best scenario because of the interest rates that we're dealing with now, but assuming you could find financing with an interest rate that you can live with, you go and you refinance, you obtain financing in an amount necessary to pay off the existing loan, you pay off the existing loan, and you own the property, continue to own the property free and clear, and you have no issues there. So basically, if a lender invokes the due on sale clause, you have three options. One is to restructure to satisfy the lender's requirements. Second, you sell the property to a third party and pay off the existing loan in the process. Or three, you refinance and pay off the existing loan in the process.